Hello friends, welcome to today's session. My name is Dr.Kapil B.Chaurpagar, Assistant Professor at Shri Omkarnath Malpani Law College, Sangamner. And today we are going to discuss the constitution of criminal courts under Bharatiya Nagrik Suraksha Sanhita. As we are aware, in criminal justice system, the role of criminal courts are very important. So, here is a small attempt to focus on the establishment and the constitution of these courts. In Bharatiya Nagrik Suraksha Sanhita, different types of criminal courts are provided and also their powers and jurisdiction are mentioned. Today, we will shortly discuss about this. As per section 6 of the Sanhita, beside high courts, there shall be other courts in every state, means that every state ordinarily have one high court, and there shall be in every state the following classes of criminal courts, namely court of session, judicial magistrate of the first class, judicial magistrate of the second class, and executive magistrates. Next point is about the territorial division. As per section 7 of BNSS, every state shall be a session division or shall consist of a session division, and every session division shall, for the purpose of this Sanhita, be a district or consist of districts. Means normally in every state, every district shall have one session. The state government may, after the consultation with the High Court, alter the limits of number of such divisions in a district. Section 8 speaks about the appointment of a session judge. As per this, every court of a session shall be presided over by a judge to be appointed by the High Court, and High Court may also appoint additional session judges to executive jurisdiction in a court of a session, and such judges would assist the session judge, and distribution of work can be done amongst them according to the orders of the High Court. Section 9 speaks about the establishment of the court of judicial magistrate first class and second class. It provides that in every district there shall be established as many courts of judicial magistrate of the first class and of the second class, and at such places as the state government may, after the consultation with the High Court, by notification specify, provided that the state government may, after consultation with the High Court, establish for any local area one or more special courts of judicial magistrate of the first class or of the second class to try any particular case for a particular class or cases. Section 10 inform about the chief judicial magistrate and additional judicial magistrate, etc. According to it, in every district the High Court shall appoint a judicial magistrate of the first class to be a chief judicial magistrate, and the High Court may appoint any judicial magistrate of the first class to be an additional judicial magistrate. It means that High Court appoint chief judicial magistrate and additional chief judicial magistrate. Chief judicial magistrate, that is CJM, is basically a magistrate of first class, but among the other he enjoys the higher status and special responsibilities. Section 11 speaks about a special judicial magistrate. High Court may, if requested by the center or state government, so to do, confer upon any person who holds or has held any post under the government all or any of the powers conferred or conferable by or under this Sanhita on a judicial magistrate of the first class or of a second class in respect to particular cases or to particular class of cases in any local area. Means High Court confers the power of JMFC or JMSC to any person who holds post under the center or state government, provided that no such power shall be conferred on a person unless he possesses such qualification or experience in relation to legal affairs, as the High Court may, by the rules specify, means the person should be well acquainted with the knowledge of law. Such magistrate shall be called special judicial magistrate and shall be appointed for a term not exceeding 1 year at a time, means his appointment will be basically for 1 year. Now, we will discuss about the executive magistrate. Along with the judicial magistrates, Sanhita also provides for the executive magistrates. Thus, there are two types of magistrate. One is judicial magistrate and second is executive magistrate. Section 14 of BNSS speaks about executive magistrates. In every district, the state government may appoint executive magistrate and shall appoint one of them to be the district magistrate. Normally, district magistrate DM is also known as the collector of the district. The state government may appoint an additional district magistrate. It further speaks about the appointment of sub-divisional magistrate. The state government may place an executive magistrate in charge of the subdivision, and the magistrate so placed in charge of a subdivision shall be called the subdivisional magistrate. Basically, we understand that these posts are concerned with the revenue departments. This section also empowers the state government that on a commissioner of a police, all or any of the powers of the executive magistrate can be conferred. Means police commissioner can also be given the power and he can perform as an executive magistrate if the state so required. Now, section 15. Section 15 informs us about the special executive magistrate. The state government may appoint for such terms as it may think fit executive magistrate or any police officer not below the rank of superintendent of police or equivalent to be known as a special executive magistrate for a particular areas or for the performance of a particular functions. This provision enables police officer to work as a special executive magistrate. So, friends, today we have seen briefly the constitution of criminal courts. I hope that you understood this topic. See you in the next video. Thank you so much.